Hello, everybody. Hi, Ava. How you doing, girl? Getting down to the bottom. Woo-hoo. I have all these good crumbs to put on top of her food dish. Yummy, yummy, crummy, crummy. Get a twofer right there. Hi, Billy. Billy's got the treat jug tipped over. Last one. Last one. There. Ooh. Hello, Jerry Matthew Boyd. Hello, Nana Laura. Thank you for texting me and letting me know to call. Crazy old lady. I called her. I got her up. I got her in here. Oh, yep, I did. Thank you, though. Hello, Manny. Hello, Joey Bag of Donuts. Hello, Michelle Moreland, my beautiful friend. Hello, Donald Westerdale. Oh, no. I know the pain. I know the struggle. Whenever they numb me, I guess, like, my nerves cross in a weird way, and it lasts for, like, 8 solid hours, and it just it takes up so much more than it's supposed to. Yeah. It's not a good thing. I feel for you, buddy. I hope whatever they had to do helps, though. Oh. There. Oh. The bill hurts just as much. Hello, Eileen and Carlin. I ran cases in Georgia. Not last night, but the night before. And I thought of you. There she is. Hello, Mama. Yeah. No promises. No guarantees. It is YouTube after all. Hello, Otto. Yeah. There have been postings about whatever caused that major outage, but I haven't watched any of them yet. But apparently it's still affecting people, sort of. So. Hello, Dark Zoomy. Space King with you. Ha 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 ha. New rule. New rule. Excuse me. This is the one Charlie gave me. I love it. I love the other one that he gave me too, because when I'm little in the corner, it looks like I'm sparkling. Thank you. This one looks, it's supposed to look like real diamonds. I love it. I love it so much. You guys are so good to me. Hello, Linda Applegate. Oh, good. I'm glad I can make somebody feel better. Everybody's sick. First it was Nanny, and then his daughter, and Charlie, and C Rex, and Squishy got it, and oh my gosh, everybody's sick. Everybody's sick. Y'all are passing it around digitally, I swear. Not just Billy. There's 4 cats here. They've all gone into them. Oh, you are just so sweet. So I don't know what this is yet. I don't know what this one is. But I ordered a bunch of stuff, but I don't recognize. Oh, it's a shirt. It's a shirt. It's a shirt, and it's from someone. I thought you looked so beautiful in the first shirt you wore. Oh, I want you to have one similar that fits. And this one is differently cool. Love your bro, Charles. Ah! Charlie! Oh my gosh. Look at this. It's gorgeous. I love it. Thank you. Oh my gosh. And I know it'll fit. And I'm wearing another one from you, and then you send me another one. You're just, I couldn't ask for a better brother. Even my biological brothers don't love me this much. Hi, tiny kitten. Hi, silly baby. Hi, silly baby girl. Hi. You're so pretty. You're so pretty and you're so soft. Yes, you're such a good girl. You're such a good girl. Yes. Oh. And then this box here. So I can't have you guys thinking I just, grift off of you guys and have you all buy all the pets treats and I don't ever do it. So I went a little overboard buying treats. But a while ago, someone had sent some freeze-dried treats. I know Purple Kiv had at one point. I think someone else had too. And they just loved them. And all of them can eat them. And so I went on a bender. Most of them are in here, but there's another box out in the kitchen that has another package. But there's freeze-dried chicken. It's frickin' chicken! And then this is another brand of freeze-dried chicken breast. Freeze-dried duck breast. Oh, Tiny. You want some of that? You want to try some duck? Oh boy, she's right into it. Here, let me move these. She's right at it. She's like, give me that duck. And then I got Ava some duck rings. And then freeze-dried quail yolk. And I think this is a mix. Oh, yep. So this has freeze-dried chicken, chicken heart, chicken liver, quail egg, salmon, and pumpkin. So this is a dog and cat blend. And then there's another one in the kitchen, and then there's actually more coming, because I know I ordered Ava some more of those chicken rings that Jerry had gotten her that she loved so much. But I figured, straight up protein, these are going to be so good for them. Let's see if Billy likes the quail egg yolk. You want to try that, baby? Not so much, huh? Tiny kitten, you want to try? Tiny's just going crazy on the duck. You want to try some duck? Ava's like, I'll try some duck. I'll have some duck. I'll have an egg too. You want some duck? You want to try egg yolk? Ooh, yes, she does. I think Billy's not so sure on the texture. He's sniffing those egg yolks. Earl, you were just here. You were just there. You are. You want some? Here you go, baby boy. Here you go, Earl. Oh, okay, it's warm. Okay, you need to slow down. You need to get some water. Because once you add water to freeze-dried duck, I'm sure it's going to expand and your tummy going to get real full real fast. And I don't want to clean up puke. Are you happy now? I want to see one of them try one of these egg yolks other than Ava. Want to try that? She's trying it. She's trying to figure out how to get that ball in her mouth. All right. I am now very cluttered with treats. Okay, can you move, please? Please? You want to try a duck ring? All right. Hi, Billy. Well, it just kind of makes sense to me that would be a thing. I know it's a thing with jerky. Like if you overeat on the jerky, it it will expand in your tummy and make you very, very sick. Don't ask me how I know. Isn't he great? It's so great. Oh no. It won't be us. It'll be Mrs. Donuts. He has such great taste. He's such a great person. I love him so much. I have one good one. I have one good one. Well, you guys are my family. I'm not exactly his type. Oh, Earl's reaching out for Ava. Hello, Purple Kiv. Yes, I believe you were the first one to send freeze-dried treats. If you'd like to, absolutely you can. Weird. Even just saying hello. That's silly. That's absolutely silly. Oh, sorry guys. My fresh out of the shower, my hair's still a little damp. Yeah, only because there's treats involved. If it was just me, they wouldn't care. Not as much anyways. I know. Bless you. You okay there, pumpkin butt? You goof. Well, she's got, four influencers. Well, it has to. It has to. They've trained me. They have trained me. Who would have thunk it? Yeah, there's only a few species that do that. No, I beg to differ. not not that I not that I think that there is. It's just yeah, you get real sick. and so I have to give the disclaimer. Hello, Mark Addie, honey. Why else do you think they stay together for life? the same way my Grammy and Grandpa did. Duct tape. Okay, well, if you want to email them to me or any of the crew, we'll get them up there. I made bacon tonight too. I prepped bacon for the week. Hello, Mortimer Duke. How you doing? We're just having a treat fest over here. All right, guys, we are going to start off in Kansas. And then after Kansas, we're going to go to Ohio, for Joey.
Good morning. This is in the state of Kansas versus Jacob Dean Stevenson, 25 TR 115. Would counsel state their appearances, please?
May it please the court, this date appears by Judge Black, County Attorney.
William McClendon for the defendant, Jacob Stevenson, who appears from the Elk County Sheriff's Office.
All right. We're here on the defense motion for modification of sentence. It appears that, well, there was one filed in November. Counsel, had you filed something more recently?
I have not, Your Honor. This was Mr. House's motion. The only motion I'm aware of is the one from November.
Okay, that's fine. I just wanted to be sure. Well, it's the defense motion, so I'll hear you now.
Yes, Judge. Mr. Stevenson, he was sentenced on July 23rd, 2025 to a 12-month sentence for his third or subsequent driving while suspended. Today would be his 184th day there in the Elk County Jail, and he'd be requesting a modification of his sentence to probation. Court services for 12 months. He has other traffic cases he needs to get resolved and pay fines on. He has a job as a heavy equipment operator, and at the very least, he's still with the company. He's forgive me, he's still with the temporary employment company he would be working for at the very least. So we'd request that he be placed on probation for 12 months and resume his employment for the above for the reasons I stated earlier.
Well, what is this employment and how is he going to get to that if he has warrants in other districts? How many warrants does he have? What's he have facing him?
I'm not aware that he has any warrants, Your Honor. I believe most of them are just court costs and fines that he has to pay. I'm not aware of any warrants that Mr. Stevenson has at this time.
Are there holds placed on him where he's been served with a warrant?
I do not know, Your Honor. Mr. Stevenson, do you know? Do you have any holds out there?
Yes, I have one out of Douglas County, which is a probation violation because I'm in here. I didn't get to my probation meeting. That's all that is.
Hold on. Was this motion in file before you went to jail here?
No, he did it while I've been incarcerated. He filed the motion after 90 days, and then he told me that after 100 or after 6 months, it would be reevaluated or whatever.
All right. Mr. McClendon, anything else?
That's all I have, Your Honor.
Ms. Gillette?
I don't know, what the court's thoughts are. Mr. Stevenson, I was looking up whether or not he had warrants, in Odyssey. And there is,
Two.
I don't know what the P means next to his name, but he does have warrants. And so, just looking to see which ones were outstanding. There's one outstanding, and it says it's Osage County.
He's outstanding.
Yes.
So, that is accurate. He has an Osage County warrant. I know the court sentenced him. If the court wanted to, change his sentence from in custody to house arrest, so that he could work, I wouldn't mind that, but he would have to go to Osage County first, and I don't know how we make sure that he has a bracelet on if he goes up to Osage County before being released.
All right. Does anybody have information on what this job is? All we keep hearing is, yeah, well, he has a job to go to, and if he doesn't, then he's got a temporary job to go to. So if somebody could give me particulars in regards to this, please.
Mr. Stevenson, can you tell us where you work?
I can't remember the name of the place. I've been in here for 6 months, and I've been dealing with.
Guys, is the video frozen for anyone else? Or is it just me? I'm getting nervous. I really don't want it to crash. And YouTube's been having issues the past couple days. That's why I wasn't on last night. Oh, no. No. Dag nabbit. Ah! Okay. Maybe it's my editing software being goofy. I love that Earl meowed just as you posted that. All right. Well, it's either my editing software or StreamYard or YouTube, and I'm sure we'll know very soon.
Go to. So if somebody could give me particulars in regards to this, please.
Mr. Stevenson, can you tell us where you work?
I can't remember the name of the place. I've been in here for 6 months, and I've been dealing with the Osage County stuff and talking to my attorney out there, and I'm trying to remember it. I know exactly where it's at. Man,
What did you do there?
I heavy equipment forklift operator. I ran a crane that picked up heavy concrete. It's a concrete manufacturer.
How do you work for someone and not even know the name of your employer?
It's on the north side of Topeka. Gosh. What is that place?
Anything further, counsel?
I have nothing, Your Honor.
Mr. Stevenson, Mr. McClendon has argued on your behalf. Is there any statement you'd like to make before I announce my decision?
No, sir.
Well, Mr. Stevenson, you didn't come off very well with me when you were sentenced. You keep accumulating charges, and you kept accumulating charges, and to a large extent were the same charges all over the place, not just in Elk County, but others. And, you know, it was just one excuse after another to try to get sympathy for you. And here I'm hearing the same thing. You know, oh, I've got a job. Oh, I can't think of where it is. I don't know who I work for. That's just more of the same. Motion is denied. Anything further on this matter today?
No, Your Honor.
I will not consider any additional motions on this. Hey, Mr. Stevenson, you're gonna serve your time. You're gonna start learning, at least have a lesson put out there for you. Whether you'll learn from it or not is, you know, when a judge places you on probation, you have things to do, and you've avoided that completely.
No.
Now, don't shake your head at me. I know what I've seen, and that's my ruling. So we are adjourned. Thank you.
25 CR 373. Brett Sweeney appears for the state of Kansas. James Watts is defense counsel. However, Edward Luna has not appeared.
I have a feeling that it was something to do with the exporting process or something. I've got the raw video file of that case. I can always upload it independently as a replay crew mini and just add some text or something in there if you guys really want to see the video moving. I'm sorry that it did that. I'm still learning that software. It could be something I did. I'm really sorry.
Court's docket notes indicate that Mr. Luna appeared before this court on November the 3rd of 2025. At that time, he pled guilty to possession of fentanyl, a level 5 drug felony. The court ordered a pre-sentence report and set sentencing today at 10 o'clock a.m. It's now 12 minutes after 10. Mr. Luna has not appeared. Do you have an explanation for this, Mr. Watts?
I do not, Your Honor, and I will let the court know. I have a phone number for Mr. Luna. I have called. I have gotten a machine with that there is no message, that the machine is full and I can't leave a message. I did get a call from Mr. Luna yesterday afternoon when I was unavailable, and I called him back after that call and again got the machine, and I got a machine again this morning. And again, the mailbox is full. I could not leave a message, so I've not been able to contact Mr. Luna.
All right. Mr. Sweeney, do you have any information as to why Mr. Luna would not be available?
I don't, Your Honor.
Very well. The court declares that the defendant has failed to appear. He was specifically ordered to appear at the Judicial Center for his sentencing at 10 o'clock a.m. He's in default of that appearance requirement. Court orders bond forfeiture, a bench warrant issue for the arrest of Edward Lewis Luna Jr., with him to be held on a strict no bond hold pending future sentencing proceedings in the case. If you prepare appropriate paperwork in that regard, Mr. Sweeney.
Yes, sir.
Thank you. Thank you for the attendance of all of the other professionals that were on this meeting. At this time, the court will declare the Luna case in recess, titled State of Kansas versus Edward Lewis Luna. It's case number 2025 CR 373. James Watts appears as defense counsel. Brett Sweeney is prosecuting attorney. Edward Luna appears from the Butler County Detention Center's Zoom location. Kelsey Moore appears from court services, substituting for Chastity Altus, who is the pre-sentence investigator in this case. This matter comes before the court at this time for sentencing. Docket notes indicate that Mr. Luna appeared before this court on November the 3rd of 2025. At that time, pled guilty to count 1, possession of fentanyl, severity level 5 felony. On the drug grid, other counts were dismissed. Pre-sentence report was ordered. Sentencing originally set for December 31 at 10 o'clock in the morning. Docket notes from December 31 indicates that the defendant was allowed extra time to appear, but failed to appear. Court ordered bond forfeiture bench warrant with a strict no bond hold, as the defendant was presumptive prison at that time. Sentencing was to be reset when the defendant was taken into custody. There were docket notes from January 9, apparently held before a different judge on a first appearance docket. At that time, it would appear that sentencing had been reset till January 26 of 26 at 4. Mr. Watts' appointment as counsel obviously was maintained, with the no bond hold remaining in effect. I don't have any docket notes from January 26, but ostensibly the matter was continued to allow for the defense to file the departure motion. Mr. Watts?
That's correct, Your Honor. And
Very
same
well.
was filed on February 12th.
Court has a copy of that motion before it. Court has the completed pre-sentence report before it at this time. Does the state have any objection to the criminal history as stated in the report?
No, Your Honor.
Does the defense, Mr. Watts?
Your Honor, reviewed same with my client. We believe it is correct. Have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score C, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentencing should not proceed in the Luna case here this afternoon?
None that I know of, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Mr. Luna, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with sentencing today?
No, Your Honor.
Court proceed further then. Now, counsel, I am aware that there's been a motion for a departure filed in this case. The motion is entitled Motion for Dispositional/Durational Departure, as submitted by Mr. Watts earlier. Court is familiar with the contents of that motion. You may proceed further regarding that motion at this time, Mr. Watts.
Your Honor, I'll just track the motion briefly. Mr. Luna is a C on the grid. We know what that means. However, Mr. Luna would also, even as a C on the grid, qualify for Senate Bill 123, but for his 3 strikes. This is a 3-strike case. As the motion notes, one of those is fairly recent. It's a 2018 case. The other 2 cases that make him qualify as 3 strikes are quite old. They date back to 1999 and 2000. And what happens in between, as I note here, is mostly, not entirely, but mostly driving offenses. I would note, as I had before with Your Honor, and I know Your Honor is well aware, there is, or could have been, a provision for treatment within the Department of Corrections and then return to the community. But as Your Honor, I'm sure, is well aware, that's never been funded. So that's not an option at all in this case. The most interesting thing about this case is what Mr. Luna has done. This particular case dates to an incident in June of 2024. That's the charging documents allegations. It isn't charged until August of 2025, but Mr. Luna doesn't wait till it's charged to start taking things up. He enters a treatment program, Arista Recovery in Kansas, February of 2025, long before this case arises, and as far as it being charged, long before he's charged. He successfully discharges from that. They recommend that he enters an aftercare program, which is exactly what he does. And as Your Honor may, I will note, we sent along the certificates and the documents supporting those to email to court and counsel earlier.
I have those, Mr. Watts.
He was discharged successfully with the in service or the in custody treatment. He went to outpatient treatment after that, went through that for a number of months, starting in March of 2025 and through November. Now, the one thing, and I spoke with Mr. Luna about this, he started out really good on the outpatient portion. As the outpatient portion went along, his attendance fell off a little bit. I won't deny that's obvious when you look at it, that what started out as really dedicated attendance fell off toward the end. And then right at the end, in November of 2025, Mr. Luna had a accident at work, lost parts of 3 fingers to a machine where he works. The most interesting thing we spoke, by the way, about his job, works at Valmont. At least at the time I spoke with him, he had not been notified that he has lost that job. He may have an opportunity to return when this is resolved and his injuries heal. So he may still have that job out.
Usually when you have an injury at work, especially one that significant, they drug test you. I would be very interested to know if that happened and if he was sober at the time of incident. Very unfortunate. I don't care who it is. I feel very bad that he lost 3 fingers. That should not happen to anyone. But I am curious if there was a reason.
There. And finally, Your Honor, this is not a case where Mr. Luna tried to dodge or weave or even file any motions. This case came before the court for first appearance, or not say first appearance, but the 230 docket in November of 2025 and was pled that very day. This is one that was resolved. It is, as I'm sure I put it to Mr. Luna, it is what it is. It's take responsibility for it now and resolve it, which is exactly what he did. He has never attempted to deny responsibility. So for all of those reasons, Your Honor, we would urge this court to consider a dispositional departure in this matter to probation. He needs to get back into a treatment program, whether that be an inpatient or outpatient at this point, I will leave to the professionals, but he needs to get back into that program and resolve the issues. And most important, perhaps along with that, get back into work at Valmont. As I've told clients many, many times, perhaps the very best rehabilitation program is a job. You have a place to go, you have something to do all the time, you make money, and you're not spending your time getting in trouble. Jobs are the best thing that my clients can have in terms of being successful. And it looks like Mr. Luna may well still have that job. So for all those reasons, Your Honor, we'd encourage the court to consider a dispositional departure in this matter, place him on probation with the treatment that is believed to be appropriate in this case.
Well, it's one thing you didn't address. You argue acceptance of responsibility, but Mr. Luna accepted responsibility by not showing up for his scheduled felony sentencing. How is that acceptance of responsibility?
Judge, I don't defend not showing up for his sentencing evaluations. And I will tell you, I think it will be speed to speak to Mr. Luna as to what happened in there. I don't deny it. He didn't show up. That needed to get fixed. That needed to get resolved, and he didn't do that. The only thing I would note, when he failed to show up, that would have been, again, right about the time when he had the accident at work and lost parts of his fingers. Now, are those two things related? I'm not sure I can answer that. And I certainly don't know that they justify it, but no, I don't have an explanation for that, Your Honor. And I won't
Very
pretend.
well, Mr. Watts. What is the state's position regarding the request for departure findings in this case, Mr. Sweeney?
Thank you, Your Honor. Your Honor, quite simply, the state is opposing the dispositional and or durational departure, and we're asking that the court just impose the presumptive sentence, which is presumptive prison via the special rule, which is, of course, the third strike, third felony possession. But not only is there the third felony possession, but he was also on probation at the time that he picked up this offense. And I've taken a look at that case, and for the court's knowledge, that's 23 TR 2050. Now that case has since been disposed of, so I guess for all intents and purposes, it's really kind of a moot issue as to whether or not that runs consecutive. But it does, I think, speak to his ability to follow the straight path while he's on probation. And I guess it's also worth note that he's been recently, and this is from the PSI, that he was recently put on probation on another case, and that is, sorry, I'm going to get that case number. I believe it's a 24 case number. I should have written it down, but he was recently placed on court services probation on January 17th of 2025. And, I think probably the most glaring thing about Mr. Luna and his criminal history is that he's got 44 entries. I will admit that, a large number of those are traffic related. But obviously within there are some substance abuse convictions, with the most recent being the 2018 conviction, or the 2018 case. And so he has had at least one drug case that's relatively recent. And so I think the idea is that, well, he should be given a shot at treatment to try to see if he can make these things work. But he's got a significant amount of criminal history, where at this point the state sees the appropriate resolution of this case to be the presumption, and then in that case it's presumptive prison, and the state's recommending the standard of mid-box 30 months in Department of Corrections.
Thank you for the statement of your position, Mr. Sweeney. Anything further regarding the departure request at this time? I will give you the opportunity for formal recommendations later, Mr. Watts.
Nothing else, Your Honor. I
All
think
right.
the motion speaks for itself.
Noting that there are no persons present to be victims or members of a victim's family to address the court, I will ask for formal recommendations from counsel at this time. Mr. Sweeney, I'm aware that you are opposing the departure motion and recommend the mid-box sentence of 30 months. Do you have other sentencing recommendations?
In large part, those are my recommendations, Your Honor. The standard mid-box 30 months, as well as the corresponding good time and post-release supervision duration periods set forth by statute. I'll have to, a little bit of hat tip here to Ms. Moore. She has updated the jail time credit for Mr. Luna at 42 days. That does seem to be correct. So I would ask the court to give credit for the same. We're not requesting a fine. We are requesting the court cost, $400 payable towards the KVI lab fee, and then of course attorney's fees if the court finds those appropriate.
How were the 42 days computed, Mr. Sweeney? He had 1 day as of New Year's Eve when he was scheduled to be in court. Then he failed to appear.
Right. And
Was he taken into custody on the 8th rather than the, do you know?
well, I have him in custody I have a hearing in front of Judge Hart on the 9th.
Yes.
So I would assume, I don't have the bond sheet in front of me, but somewhere in and around that time. And then I'm not sure if he had other holds on him, but I'm assuming that time was being calculated against any time that he would have been serving on this case, since he did have the no bond hold on this case as well. But I guess, Ms. Moore, do you have an exact date that you're referencing? If the court would like to hear from Ms. Moore.
I would. Thank you, Mr. Sweeney. Ms. Moore?
Yes, Your Honor. We spoke with Larry Reynolds out at the jail today. My office did. He has him as 1 day jail time credit from 6/20 to 6/21 of 2024, and then from 1/8 of 26 through today.
All right. I think that identifies the pickup date in which his current period of incarceration began. So thank you for that clarification. That does appear to compute to 42 days. All right. Mr. Watts, any additional recommendations regarding an appropriate sentence?
Your Honor, we join the state as to the standard mid-range of the underlying sentence with the good time post-release and probation as noted. We'd urge the court to consider departure for the reasons previously argued. I won't go back over that ground. We'd further adopt, should the court grant same, the conditions of probation here with community corrections, and of course would include a drug and alcohol evaluation should an additional evaluation be necessary given what he's already done, as well as the other normal and usual conditions of probation.
All right. Thank you, Mr. Watts. Your fees and the representation of this client?
Just this would be billed to bids at $1,100.
Thank you. At this time, the court will address the defendant, Edward Lewis Luna Jr. personally, and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Luna?
Yes, Your Honor, I do take responsibility for my charges. I did take responsibility and turn my life around during the time I caught the charges up until, around November. And that's when I had this accident. And I was just released from the doctor last Wednesday to return to work. And I do still have my job at Valmont. And I had a SAC evaluation done up here, which I'm supposed within the 24 hours report to them. And that's pretty much all I got to say at this time. So.
Very well, Mr. Luna.
Thank you.
Court will pronounce sentence in the case at this time. Court establishes count 1 in the case as the base sentence for the offense of possession of fentanyl, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of C, thus placing him in grid box 5, drug C. The court hereby sentences the defendant to a term of 28 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court finds that in grid box 5, drug C, this would be a presumptive prison case, however, subject to theoretical border box findings. But the court will also observe that there are 2 special rules which apply in this case. This is a third or subsequent felony drug possession with a presumption of prison under Kansas law. Further, this crime was committed while the defendant was on probation, apparently for a felony in a TR case. Both would justify this court entering a prison sentence in this case. Implicit in the court's ruling made so far is the court's rejection of the request for durational departure. Court will consider now whether a dispositional departure should be granted in this case or not. At some point, Mr. Luna, you need to be held accountable for the decisions you make and your conduct. This court is disturbed, Mr. Luna, that someone who was so close to prison didn't show up for their felony sentencing when scheduled on December the 31st. You leave your attorney hanging because he doesn't know what's happened to you. People show up expecting to deal with your sentencing issues at that time, but for whatever reason, that didn't cause you to be where you needed to be. That disturbs the court.
I understand, Your Honor. I had a lot of doctor's appointments going on dealing with.
Mr. Luna, I gave you an opportunity to speak. Let me just interrupt by saying that all of us in this world have a lot going on all the time. I regret that you were injured. Nevertheless, something as important as a felony sentencing on a serious drug case, and I'm going to call it a serious drug case, Mr. Luna, because this is possession of one of the most dangerous street drugs that we've ever had in our community, fentanyl. And so instead of coming and making your best argument, your best case on December 31st, you have to be arrested on a warrant for failure to appear. It certainly doesn't lean in your favor regarding whether you should be given an opportunity for a community-based alternative here. This court will simply follow the presumption in this case of presumptive prison due to this being a third or subsequent felony conviction. The court will deny a dispositional departure, finding that there are no substantial and compelling reasons to support a departure sentence in this case. And again, the court believes that the defendant should be held accountable for his conduct. The court has entered an order for a mitigated sentence less than what was recommended by the state. The court does find that the reasons stated in the departure motion, the acceptance of responsibility by plea, some efforts that have been made regarding treatment and personal rehabilitation, and somewhat dated criminal offenses on the serious side do warrant this court's consideration of a lesser than standard sentence, and the court's order reflects the mitigated sentence of 28 months. However, this is a prison sentence that's being entered by the court today. No fine will be imposed. Court will assess a felony docket fee in this case. Because of its incarceration order, will waive all bids assessments. Were there other costs which the court should consider, Mr. Sweeney? It doesn't appear that we had a KBI lab test here. At least it's not indicated on the pre-sentence report.
There was a lab test, but in looking at that, 1 second. That may have been in relation to another investigated portion of this that wasn't charged. So while one was done, I think the court's accurate there.
Then the court will be assessing the felony docket fee. That is immediately due, payable, and collectible. The court does award the defendant a total of 42 days of jail time credit, as earlier discussed. Some point in the future, Mr. Luna, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer, and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas may have the right to appeal their conviction to an appellate court having jurisdiction, and if such defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Luna, you, the defendant, have 14 days after this judgment to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Sweeney, are there other sentencing related matters which the court needs to address or readdress?
No, Your Honor.
Mr. Watts, are you aware of anything further?
I don't believe so, Your Honor. When we finish, could I have a brief breakout just to discuss the possibility of appeal, whether or not we wish to pursue that?
You may have that. We'll keep the Zoom meeting open for that purpose. Mr. Luna, as you go off to the Department of Corrections, I would encourage you to try to earn every good time credit day that you can.
Absolutely.
Participate in whatever rehabilitative programs that might be offered so that you'll be in the best possible position to be successful when you get out.
Yep, absolutely.
I'll remand the custody of Edward Luna to the representatives of the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 28-month prison sentence which the court has imposed here today. We will, at this time, recess proceedings. As the court proceedings are over, we will leave the Zoom meeting open to allow.
All right. So, defendants in Kansas aren't having a good day. The judges are not having it.
The county municipal court is reconvened.
Please be seated. All right, we're on the record here in 26 TRD 00581. Stevie Zachary Williams, the defendant is present in the courtroom today. He does not have counsel. Defendant is charged with 1 count of speeding, minor misdemeanor, and 1 count of driving without a valid driver's license, which is an unclassified misdemeanor. Mr. Cox is here on behalf of the state of Ohio. Is the state ready to proceed? Yes, Ron. And Mr. Williams, are you ready to have your trial today?
Yes, sir.
Now, you don't have a lawyer with you, and you do have a right to be represented by an attorney, but under these circumstances, it would be your obligation to pay for an attorney. The only time that you're eligible to have the court appoint one at no charge is when you're facing possible jail time as a result of what the charges are, but that's not the situation here. Was your intention to waive your right to an attorney and to represent yourself?
Yes, sir.
Very well. Court will accept the waiver of counsel. Mr. Cox, please call your first witness.
Officer Meade, Your Honor.
Officer, please come forward and be sworn.
Just raise your hand. Just solemnly swear, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, and nothing but the truth?
I do.
Is that what you say? For the record, you're going to give your name and spell your last name.
Officer Meade, M-E-A-D,
And the address of your employer.
59599 South Main Street, Johnstown, Ohio.
You may inquire.
Thank you. Officer Meade, how long have you been with the Johnstown Police Department? Approximately 8 months.
8 months, you said. All right. Did you have to be working back on December 3rd of last year, 2025?
I was.
Were you wearing the uniform of the day, such as the one you have on now?
I was.
Were you operating a marked cruiser with a visible functioning light bar?
I was.
What's your general job duties as a Johnstown police officer?
Patrol the city, regulate or control traffic, or regulate traffic, and to answer calls for service.
Does that include enforcing the traffic laws of the state of Ohio
They do.
and the criminal code thereof?
It does.
All right. Now, separately, do you have any training with regard to radar speed enforcement?
I do.
Can you please describe for the court your training with that?
I received training both in the academy and during my FTO period.
Okay. What did your training teach you or inform you about?
Both the function of the radar, its engagement, and the function of testing as well,
Sure.
as long as the Doppler effect.
Certainly. As far as the training, did that include a visual estimation of speed component?
I did.
Could you explain what that means to the court?
It means that observing that the vehicle is above the posted speed limit and then being able to confirm it through radar.
Certainly. And as far as that visual estimation of speed component, do you have to hit a certain threshold of accuracy?
±5.
All right. And did you fulfill that requirement?
I did.
Now, you spoke about the radar unit itself and how to use it. How do you ensure that the radar unit itself functions?
At the beginning of my shift, I always test the unit with tuning forks. There is a 20 mile an hour tuning fork and a 50 mile an hour tuning fork assigned to my unit. At the beginning of shift, I initiate the unit, turn it on. It goes through a normal test, which it passed that day. I then take the 20 mile an hour tuning fork, set the unit to stationary and forward, tap the tuning fork on the support of my in-car computer, put it up against the antenna. System then reads 20 ±1. And then I do the same thing with the 50 mile an hour tuning fork, and it did again read 50 ±1. After that, I set the unit on mobile, again, put it into forward motion. I clear both tuning forks at the same time and tap them on the support, hold up in front of my antenna, and I get a 30 in the reading window and then a 20 in my window or my speed window, in which it did pass that day.
Certainly. So you go through that confidence check in both the stationary mode as well as the moving mode itself.
Correct.
All right. And on that day, did the results come back consistently what you would expect or with your training?
Correct.
Okay. And are you up to date at this time with your training as far as mobile speed enforcement?
I am.
All right. Now you mentioned the Doppler effect or the Doppler principle. What is that?
It is essentially that the radar uses sound waves, bounces off of the target and comes back and then reads you its speed.
Okay. So on December 3rd of 2025, you performed that confidence check. Did you take that unit out of service at any point during your shift?
I did not.
Were there any errors that returned during your shift?
I did not.
Okay, there were no.
Why not?
Okay. At approximately 12:36, or let's see, yeah, 12:36 a.m. Do you recall where you were in the city or state of Ohio?
I was in our city, the main town center, on West Coshocton and the shoulder of West Coshocton, facing the eastbound.
So you indicated that you were in the village of Johnstown, Lincoln County, Ohio.
I am.
Okay. Do you have to have contact with the gentleman later identified as Zachary Williams?
I did.
How did that contact come about?
I was running radar on West Coshocton when I observed a vehicle approaching in the westbound lane coming towards me. It was the only vehicle on the street at the time. I estimated that the vehicle was above the posted limit. I confirmed that with my radar. It confirmed to be 40 in the 25 zone.
Okay.
I then locked the radar system. As he passed me, I flipped on him, initiated my emergency lights, and initiated a traffic stop.
Do you see Mr. Williams here in the forum here today?
I do.
Communicate where he's seated and what he's wearing, please.
Defendant seat.
Sure. To my right,
Yes, sir.
in the dark shirt.
Yes, sir.
All right. Your Honor, I asked the record to reflect that the witnesses identify Mr. Williams.
It will so reflect.
Thank you. And you mentioned over the posted speed limit. What is the posted speed limit in that area?
25.
Okay. So you'd indicated, if I'm understanding your testimony correctly, that there was a lone vehicle and the vehicle was headed down the road. You visually estimated over the posted speed limit of 25 miles an hour, used the radar device, returned what was the speed?
40.
Okay. Is there any audible tone or anything associated with the radar?
There's an audible tone when I initiate the unit.
And what does that mean? What is in a functional sense?
The unit, as part of its function, returns an audible tone for the speed. Roughly a higher pitch means faster, lower pitch means slower. It was a high pitched signal, so I knew it was a higher speed. And then I visually confirmed on the LDA display that it was 40.
So the tone was consistent with what you expected as the vehicle moved. Did the vehicle travel in front of you?
Correct.
Okay. Did the pitch increase in intensity as it went travel in front of you?
It did.
Okay. Did you lose sight of the vehicle at any point in time?
No, a brief moment as I flipped on the car, but I observed it in my rearview mirror.
Sure. And were there any other vehicles in the road that could have interfered with that?
Was not.
Okay. You flipped on the vehicle. Did you activate your overhead lights?
Did.
What happened next?
After I initiated a traffic stop, I approached the vehicle. Mr. Zachary was sitting in the driver's seat, the sole driver in the driver's seat.
Sure.
He expressed to me that he only had a temporary permit. I asked him for all of his identifying information. He said he just bought the car and didn't really have registration on it yet. I was able to confirm that.
Certainly. So just make sure I understand again. How many people were in the vehicle?
Just one, just Mr. Zachary.
So he was driving solo?
Correct.
Okay. May I approach the witness, Your Honor?
You may.
Certainly, I'm going to hand you what I've marked as States Exhibit 1 and 2. And take a look at both of those for me and just let me know when you're ready.
I'm good.
Certainly. We'll start with States Exhibit 1. Can you identify that for the court?
It's a BMV record showing Mr. Zachary's driving history.
Sure. And you say Mr. Zachary, you mean Zachary Williams?
Correct.
Did he provide you with biographical information, date of birth, name, all those identifiers, social security number, things of that nature?
He provided me with a physical temporary permit.
Did it have that set of information on it?
It did.
All right. Is the information that was on that temporary permit consistent with what is on top of that document, Exhibit 1?
It is.
Okay. And on that document, where would that document have come from?
Would have come from essentially what I would have received when I ran his name on my MDT.
Sure. And what is an MDT?
It is my in-car computer.
Sure. So the mobile data terminal.
Yes.
Okay. So you punched in his information and that information comes out.
Correct.
What does that document reflect as far as a driver's license status?
It reflects his current status, is also any violations that he would have had connected to that.
Sure, but on the date that we're talking about, December 3rd, what's his driver's license status?
He has a temporary permit.
So not a full permit?
Correct.
Is one with a temporary permit permitted to drive without another person over 21 in the vehicle?
They're not.
Okay. So that was the mobile data terminal.
Correct.
Okay. Is that a fair and accurate representation of what you received from your MDT back on December 3rd?
It is.
All right. Moving on to exhibit number 2. Can you identify what that is for me?
Looks like the court record of his driving history.
And if I may approach again. You may. Certainly. Well, I'll fan the white for you a little bit here. What's the top line say here?
Record request certification.
This
Oh,
one.
sorry. Ohio Department of Public Safety.
Certainly, and there's an official, there's a seal here.
Correct.
Is that seal, this document would be from the Ohio Department of Motor Vehicles?
It is.
Appear to be a certified record.
Yes.
All right. As far as the information contained therein, is there any information regarding Zachary Williams
It
on the next page?
sorry, it does.
All right. Is that the same date of birth, biographical, and other information consistent with what you received back on December 3rd of this year or 2025?
It is.
Okay. Does that document reflect a driver's license or driver's license status? If I may again, Your Honor. You may, and you have continuing permission to do so. Thank you, Your Honor. Appreciate it. As far as here, temporary status, what does that indicate?
Temporary status is valid.
Sure. So, and as far as any other license indication, reading this document, what is the status of his license?
He has a temporary permit, or he does not have an active license when he has a temporary permit.
Okay. Thank you.
So, I mean, he's half legal with his driving. He just doesn't have another adult with him while he's driving on his restricted temporary permit, which could be a problem.
All right. After gathering all that information, and you had indicated, did Mr. Williams tell you that he had solely a temporary permit?
He did.
Okay. Did you issue a citation in this case?
I did.
For what?
I issued him for driving without a driver's license and the speed.
All right. So 40 and a 25 and the no operator's license?
Correct.
All right. No further questions. All right. So, Mr. Williams, you have the right to ask the officer questions. Once the state has rested its case, you'll have the opportunity to testify on your own behalf if you wish. But this portion of the trial is for questions only. Do you have any questions for Officer Meade?
I do.
Then you may proceed.
I'd ask for both discovery, may I?
You may.
I just want to say I'd ask for discovery proof of like, so the radar device you
Mr. Williams,
use.
you can have a seat.
Okay. I'm not very good at this, I'm sorry.
Take your time.
But that I'd ask for the serial number, the most recent calibration records, and then also the actual certificate as well, that be on record, that these are all there.
Sir, this is the day of your trial. The time to ask for discovery is at least 2 weeks past. At least.
Just because we hear it doesn't mean it's true.
Mr. Cox, do you have a response? Yes, we've received no formal demand for discovery at this point in time. There's no request that was even made during the pre-trial that we had earlier. So I think at this point that request is mooted based on the fact that we've proceeded to trial, would have provided those items had they been requested. But furthermore, we don't need to provide those items to prove this case. Testimony is evidence. So ask the court to overrule that motion insofar as it applies here. So the way that the trial process works is that there's a lot of stuff that happens before you even get into the courtroom, one of which is what's called a demand for discovery. Once
The thing is,
do you mind if I talk?
I'm sorry, sir.
Once a defendant makes a demand for discovery, the prosecutor has to provide any evidence, whether it be that tending to show guilt or that tending to show innocence, to the defendant or his attorney, if the person has an attorney. That has to be done prior to the commencement of the trial, and for that reason, your request is untimely. So I'm going to deny the request.
I would say, though, if I may, that I did ask for this at the Johnstown court when I went to that, but I guess.
Submit that in writing.
No, but they said I could just ask for it,
Well,
and I did, and then
they
they
are
moved
not
it,
lawyers.
so.
They are incorrect. So, do you have questions for Mr.
Yes, I would ask, well, actually, I think that was the only question I had, but I had some things I wanted to point out.
You'll have an opportunity to testify on your own behalf if you wish after the state has rested its case.
All right.
But no other questions for the officer?
No.
Okay. Officer Meade, you may step down. Thank you, sir. Any additional witnesses on behalf of the state?
No, Your Honor, no further witnesses. State would rest subject to offering states 1 and 2 into the record.
So at this time, Mr. Williams, the prosecution is asking me to admit the exhibits that were identified by the officer and testified about into evidence. If I grant that request, that means I'll be able to consider those documents in determining whether or not the state has met its burden of proof. You have a right to object to their admission, or you don't have to if you don't have any problem with them coming in. Do you object to those 2 exhibits coming into the record, being admitted into evidence?
Well, I'm contesting the speeding, but for the no license, is that because it went to trial?
They have to prove beyond a reasonable doubt that you were operating a vehicle without a valid operator's license in violation of Johnstown Codified Ordinance 335.01A. In order to do that, the prosecution is offering up certified records from the Bureau of Motor Vehicles that purport to indicate that you did not have a valid license on the day in question. Now, if I grant the request and accept those, that means I can consider them. It doesn't mean that they carry the day. It doesn't mean that they don't. It just means that they would be available for the court to consider in determining whether the state has met its burden. So do you have any objection to 1 or 2 or both coming in?
Well, to be fair, I wasn't driving with a full license, and I won't contest that. But I'm trying to get my license.
I understand,
The speeding is what I've wanted to contest because I don't believe I was speeding in the way that was described, and I have things that I did research on that proves what I felt.
And again, you'll have the opportunity to testify on your own behalf if you wish, but just yes or no, do you have an objection to those exhibits coming in? The documents from the Bureau regarding the
No.
license test? Okay, well then states 1 and 2 will be admitted without objection. Does the state rest?
Yes, Your Honor.
Okay, so Mr. Williams, as I mentioned, it is the state's burden to prove the charges beyond a reasonable doubt. You have no obligation to call any witnesses, to introduce any exhibits or evidence into the record, and you're not even required to testify. And if you didn't, then I don't hold that against you. But you do have a due process right to present a defense by either calling other witnesses, introducing exhibits into the record, or testifying on your own behalf. So other than yourself, do you have anybody that you'd like to call as a witness?
I would testify first, and then I do have someone to call, yes.
Okay, are they present here today?
Yes.
Okay, very well. Then you may come forward and be sworn. You can take your phone with you.
Raise the right hand. Solemnly swear, do you affirm that the testimony you're about to give us the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Please have a seat, sir. For the record, give your full name, spell your last.
Zachary Williams, and my last name is spelled Williams.
All right, so Mr. Williams, you don't have a lawyer to take through your testimony, so it just takes the form of you basically giving me your side of things. So you can start whenever you're ready.
I was driving late at night, and the visibility was low. The weather wasn't the best. I'll also say that. And I've driven a lot of places, and I want to point out that on Johnstown Road, it's like 55 miles an hour all the way down. And as soon as I hit construction around there, it suddenly went from 55 to 45 to 25. And in the state of Ohio, it is, hold on, ORC 4511.091 that there has to be, oh no, sorry, never mind, that's the wrong one. Hold on. There has to be signage. I'm not sure what that was, but there has to be signage for slow down. And I know visibility wasn't the best, but I was paying attention to the speed, and I didn't see any sudden slowdown. It just went from 55 to 45 to 25, and I wasn't aware that when I was slowing down to the stoplight, that it was 20. And I did make a full and complete safe stop. I wasn't speeding recklessly. And it's hard because when I did the math on that, that would have meant that from the 45 to the 25 sign from where I got pulled over at, it was 800 to 1,000 feet. If you think about that, if a car is going 45 miles an hour packed on the 55 and they're slowing down, they had like a dozen seconds. You would have just seconds to slow down. And because of visibility, it's like I'm slowing down, and I didn't want to slam on my brakes just so that I didn't get pulled over. And I was thinking about that. So I slowed down slowly, hoping that when I reached the stoplight, that would have been fine. But once I had passed the fire station, I wasn't going 40, but at least I didn't think I was going that fast. It's just, I saw a cop on the parallel side, and I knew that it might have looked like I was speeding, but I was slowing down. I to my understanding, I thought it was still 35 at least, but in the town it's 25. And that's, I mean, it was hard to see, but it wasn't that I couldn't see. It was just that if there was signage that would say slow down ahead, I didn't see that. And I didn't even see a 25 sign until I hit the stop, until I went past the fire station. So I thought it was 45. And something was telling me to slow down. I didn't slow down until I got into the town. And even then, I guess I wasn't slowing down quick enough, because then I got pulled over. And I will say I made a complete and safe stop at the stoplight. There is that. And I also don't live in that area, so it was an unfamiliar area. I was coming back from purchasing the vehicle, so I didn't mean to speed, but I didn't know where I was. And that's, I would say that I'm not guilty of speeding because it was an unfamiliar area, and I was driving very safely, and I had no intentions of speeding. It was also dark. It was later at night. I think that's all I have. Yeah.
Okay, Mr. Cox, do you have any cross-examination for the defendant?
Just a little bit. Just to confirm, Mr. Williams, you were driving on a temporary license while you were alone, correct?
Yes.
Okay. From your testimony, you are unclear of how fast you were going, correct?
I was not speeding. I don't know how fast I was going past. Like, I wasn't trying to speed. So, I mean, not sure of how I'm not sure where 40 came from.
So that's a yes or a no, sir.
Yes.
Okay. But by your own testimony, you're not familiar with the area, and it was dark, correct?
Yes.
And you can see that you were passing or near the fire station in the village of Johnstown, correct?
Yes.
Further questions, Your Honor?
Okay, now you have a right to respond to the questions that you were asked by the prosecutor. It's called redirect testimony. Is there anything you want to say in response to the questions that he asked you?
It was unclear of how fast. Like, I wasn't. I'm not sure that I was. It's unclear of how much faster I would have been going in that area, but I wasn't trying to go that speed. And also, that because of the unfamiliar area and the dark conditions, that also might not have been possible for me to see a sign if there was one. But to my knowledge, I didn't see anything. And to my knowledge, I also still thought I was going a correct amount of speed, and I did slow down correctly. So past the fire station.
Okay. And Mr. Cox, any recross?
I don't have any recross, Your Honor. I would like to recall Officer Meade on rebuttal.
Well, we need to see him wait for whether or not the defendant rests or not. You may retake your seat, Mr. Williams. And I believe you indicated you don't have any addition. Oh, yes, you did say you had another witness that you wanted to call.
My mom.
All righty. Please come forward, ma'am. Go ahead and step up onto the witness platform and then turn and face the bailiff, if you would, please.
I solemnly swear to you affirm the testimony about to give is the truth, the whole truth, and nothing but the truth, and nothing but the truth.
Yes, I do.
Please have a seat, ma'am, for the record. We're gonna give your full name. Spell your last name.
Mary Sterlitz, Sterlitz.
Okay, so, Mr. Williams, you may inquire of your witness.
Okay, approach. May I approach, please?
Do you need to show your mother something?
No, I don't know. I just have some questions.
Then you may proceed right there from the table.
So on that night, which I'm not very good at this, and I do apologize. So I'm trying my best.
Don't overthink it. Just ask your questions. Just be straightforward and simple.
All right. To your knowledge, did you see the officer in the same spot at the same time, still as a speed trap in this unfamiliar area, where, like, most people may not realize that there's no signage and that it goes immediately to a 25?
I'm just going to object to the form of the question at this
It
point.
Yeah,
very
it's kind of a run on, just ask one thing at a time.
Was the officer where he was last time? Like to your knowledge, do you see an officer in the same spot as where I was pulled over?
Yes, I was traveling outside through Johnstown, and as I was leaving Johnstown, there's a hill that kind of crosses up, and I saw. I don't know if it was this police officer, but I saw a police officer sitting right where the speed changes down to 25.
Do you think that someone who is unfamiliar with the area would have a hard time with driving through that area, like because of that?
Yes.
And do you think that because of the sudden speed change that may be hard for someone to slow down correctly, especially not knowing the area?
Yes.
And do you think that because of where the speed trap is, that may be unjust, maybe, or not?
But object to the form of that question too. Your Honor, is asking for speculation as to the morals of speed.
Let me rephrase.
It's not chanting Attica, so I'm going to overrule the objection. You can answer the question. I believe the gist of it was, do you think it's a speed trap? And is it unfair?
Do you think it's an unfair speed trap?
Yes.
Any additional questions?
Did you see any sudden speedage or anything that would indicate you need to slow down within the 500 or the 800 to 1,000 feet that goes from 45 back and then past when it goes 25?
I don't recall seeing any signage stating that it was going to drop down to 25 and to slow down. No.
That wasn't his question. He asked if you saw any speedage. No, I'm not quite certain what speedage is, but I didn't see any. I reckon you didn't see any either.
So does that mean that, so do you think then that if someone was driving through there and it might have not been the best visibility, that it would have been hard for them to determine when to slow down correctly?
If there's low visibility, it would make it difficult to see any kind of signs. Yes.
And furthermore, would that then make that speed trap more unfair, you could say, to the driver? Because they don't even feel like they were speeding?
I don't think it's unfair. No.
So do you think that the visibility made it hard then?
Object asked and answered.
Yeah, you did ask her that. She did say yes, and so the court has heard that testimony. Do you have any additional questions?
No.
All righty. Any cross?
Briefly, ma'am, good morning. I think it's still the morning. You apparently have some familiarity with the village of Johnstown and speeds.
I don't, but I do know traffic laws. I've been driving for 40 plus years, and I know that.
Sure, but you testified that you were familiar with where there's a change in speed from 35 or more down
Only
to 20.
because I drove through there like twice.
Okay, but you have an awareness of that, correct?
Yes.
All right, so there is a distinction between a higher speed zone and a lower speed zone as you're going
Yes.
through village of Johnstown. Okay, and you acknowledge that there's a drop to a 25-mile-per-hour zone, correct?
Yes.
Further question, Charlie.
Do you have any follow-up questions for your witness based on the prosecutor's questions?
Yes.
Go right ahead.
Would you argue that the drop in speed is sudden and makes it hard for you to see when you would need to slow down? Even given the familiarity of your traffic laws.
Are you asking me personally?
Yes.
No, because I know the traffic laws.
Okay,
And
so for
driving through any town or city or village, it's 25.
So for a newer driver, if they're driving through an unfamiliar area and it goes from 45 or 55 to 25 and it's low visibility, would it be hard then for them especially if no sudden signage, to see when they might need to slow down?
Maybe that's why a newer driver who is unfamiliar with the rules of the road and unfamiliar with the signage and unfamiliar with the speedage, of course, maybe that's why they're supposed to have an adult licensed driver with them through their probationary period. What a concept!
That's possible as a new driver, yes.
And with that, you may be familiar with traffic laws and you may have driven through the area, but if they haven't, that driver, would that make it hard for them then to maybe drive as well?
Someone that's not as experienced with the traffic laws, yes.
And given the visibility, then they wouldn't feel like
Again,
they
asked and answered at this point. Yeah, at this point, you're just kind of rehashing the issues that and points that you've already made. Do you have any new questions for your witness?
No.
All right, any recross?
No, Your Honor.
All right, ma'am, you may step down. Thank you very much. Do you rest your case at this point, Mr. Williams?
Yes.
Okay. Mr. Cox, any rebuttal testimony or other?
Officer Meade, briefly, Your Honor.
Officer, if you'll go ahead and retake your place on the stand, it's not necessary for you to be resworn because I would remind you that you remain under oath, sir.
Thank you, Your Honor.
You may proceed.
Thank you, Officer Meade. As far as where we're talking about this quote speed trap, speed zone, can you describe how the roads transition from a higher speed to a lower speed?
Yes, in the area in question, the area is a 25-mile-an-hour zone. It shifts to 25 roughly around the cross street is Yardner. Around Yardner Street, it shifts to 25, approximately 25 yards back from that sign is a prepare to slow to a 25-mile-an-hour zone. It's posted just before the tech building on the right-hand side.
Okay. So, and as far as, so there is signage to confirm that says prepare to slow down.
Correct.
Do traffic laws change in the state of Ohio based on weather conditions, whether or not they're enforced?
Yeah.
Okay. Did you operate this traffic enforcement operation as you normally would on a regular basis?
I did.
Do you know Mr. Williams in any capacity other
Yeah.
than this case? Was there anything unusual about this case beyond the fact that it's a speeding and a driving under suspension case?
No, other than he stated when I pulled him over, he said he just bought the car, so the car didn't have a registered tag on the vehicle, but I was able to confirm that it was just purchased.
Certainly. No further questions, Charles. Thank you.
Do you have any follow-up questions for the officer based upon Mr. Cox's questions?
Yes.
Go right ahead.
It was later at night, yes.
Correct.
And do you agree that there might have been not as good as visibility because of that?
Not in that area. That is a pretty well lit area, both because of the fire station and because you just as you hit the 25 zone, you start to hit our street lights.
Okay. And if a person is still learning how to drive and may have just bought a vehicle, they I don't think I have anything further.
All right, Officer Meade, you may step down. Thank you. Any additional witnesses or testimony in rebuttal?
No, Your Honor.
So because the state elected to present
I
rebuttal,
would just say something.
well, let me finish and let me say something. Because the state has presented rebuttal evidence, you have the right to present what's called surrebuttal evidence, either by calling another witness or retaking the stand on your own part. Do you wish to call anybody else other than yourself in surrebuttal to the officer's rebuttal testimony?
No, I would just make a statement.
Did you wish for it to be under oath? Because in order for me to consider it and determine whether
Yes.
the state, then you're going to need to retake the stand, and you do remain under oath. So go ahead and have a seat. And as soon as you settle in, what is it you'd like to add to your testimony?
Well, I would just talk a little bit about myself. as a consideration. I'm in college. I'm an indigent college student, so if you know what that is,
I've heard of the word indigent before.
very poor. And I was supposed to be in class right now, but I had to come and do this. And I'm also I do have special needs. That's not to as like an excuse, but I would say that it does make it very hard for me to talk about a lot of things. And I just feel like, given everything that I experienced, that I might have been, I didn't drive the vehicle afterwards. I would have just taken it home and left it, and I get a speeding ticket, and it's just not even sure how I would pay that, trying to get a license, trying to do school, and I didn't know the area very well. So, I'm trying to deal with that as a newer driver and trying to learn. And I would just say the timing was not very well. And I don't feel like I even if I could pay, I'm not sure. Something along the lines of grace from the court, because it's a lot of ignorance on my part, but it's not willful ignorance. It's not because I'm a reckless kind of speeder that wants to go around and get in trouble. Really trying to move forward in my life, and this was not a very good timing.
Very well, Mr. Williams. Mr. Cox, any cross-examination? No, Your Honor. All right, you can go ahead and retake your seat, Mr. Williams. Mr. Cox, did the state wish to make any type of a closing argument?
Your Honor, we'd rest on the evidence that's been presented here today and ask the court for a guilty finding as to both of these charges. Thank you.
And Mr. Williams, you have the right to make what's called a closing argument. You kind of, in a way, did just there with your rebuttal testimony, but it's your one opportunity to argue why you think the state has failed to meet its burden of proof. You can't bring up anything that wasn't testified to by either you or the officer, or the exhibits that were contained in exhibits, because that's evidence. The fact's not in evidence. And you don't have to make a closing argument, but this is your one opportunity to try to convince the court that the state has not met its burden of proof. Is there anything you'd like to say before I render a verdict here?
I think the evidence provided is sufficient, but I would say character is a big factor too, and bureaucracy, and that someone like me may come into this system and get into it very hard from the start and not really be aware of a lot of things. And then on top of that, dealing with how do you pay things, if you have no money. And it's just been a long process, and I want it to be over with.
You're going to have your wish here shortly, Mr. Cox? No, Your Honor. Okay. Well, I think in your closing argument, you almost kind of conceded the fact that the state had, in fact, met its burden of proof. You were never contesting the driver's license charge. And there's an old saying about the reason that people rob banks is because that's where the money is. My experience, both up here and just in general, is that officers do very frequently place their cruisers in places where there's a decrease in the speed limit, because a lot of people don't slow down enough to be under the speed limit. Now, whether it's a speed trap or not, that's probably debatable. And really, fairness isn't something that comes into play. These two offenses are what we call strict liability, which means they don't have to prove that you intentionally did anything or that you were even, reckless or negligent about how you operate the vehicle. They just had to prove that A, you were traveling over the posted speed limit and that you didn't have a valid driver's license. So the main thing you were contesting was the speeding citation. You kind of alternated between it's not fair and I don't think I was going that fast. Well, the court does believe that Officer Mead's testimony is credible as to the facts that he was trained on how to use a radar device, that he was using it that day, that he double checked to make sure that it was working properly as required, and that it was. and that at one time, at some point during a shift, he saw a vehicle that he estimated to be over the posted speed limit, confirmed that with his radar device, executed a traffic stop, identified you as the driver, and was able to determine that at that time you had a permit, but not a full valid operator's license. So I do find the state has met its burden. Going to enter guilty finding. You've pretty much already made your statement in what we call allocution. But is there anything else you want to add before I make any decisions here?
Of the speeding?
No, about sentencing. I know you're going to disagree with my verdicts, but you have a right to make a statement about, what you think the punishment should be.
Well, if there was anything with driving, that'd be a plus in my favor, and good for the court as well. As for fines, I can't really pay anything, and that would be what I would say is I'm trying to do my best.
Gotcha. Okay, then for what it's worth, you're not in here being accused of public enemy number one. Mr. Cox?
Your Honor, if the court would extend Mr. Williams some grace as far as community service or no fines, the state would be okay with that given its complete lack of driving record. Thank you.
That would be fair.
And almost unheard of.
Oh man, dude, just stop while you're ahead. The prosecutor says, hey, given his basically his lack of driving history and whatever else, we'd be fine with not making him pay any fines. And his response is, that'd be fair. It's really not, sir. It's really not fair. But they're being incredibly generous to you. Maybe show a little gratitude. Humble yourself a teensy bit. What a bonehead.
All right, well, the court would point out one obvious thing regarding your ability to pay. By your own testimony, you bought a truck, and so you were able to somehow manage that. So I think you'll be able to manage some of the financial sanctions that the court's going to impose. As far as the speeding violation is concerned, I'll adopt a recommendation the state impose no fine, but order that you pay the court costs. For the no operator's license charge, that's going to be a $100 fine. Now, you will get time to pay, and they'll give you details in the clerk's office. And you can even do some community service to help satisfy some, but not all of the fines and costs. If you're interested in doing that, you need to tell the deputy clerk who processes your case when you finish up here after you leave the courtroom, and they'll put you down with probation who sets that up. Because it's not just you can't pick a place and just go do it. You have to do it at an approved place. So, and if you don't want to do that and you just want to pay the fine and cost, you can do that too. But you have a right to have a notice of appeal filed on your behalf within 30 days of today's date. You have a right to obtain a transcript of the trial today, which is required to appeal. And you have a right to hire an attorney to represent you during any appeal. But for the reasons I mentioned at the beginning of our trial about your ineligibility for court-appointed counsel, it would be your responsibility to secure the services of an attorney and to pay for the cost of the transcript. That being said, do you have any questions?
I think it was less of that I wanted nothing to come out of it, but more that I wanted to say how I felt and put that on record because I thought that was very important.
Okay. And you know what? That's what this court remembers every single day. It doesn't matter whether you're here on a speeding ticket or whether you're here on a domestic violence charge. It's the most important thing in the people's lives that are involved in that case, and the court treats it that way. So I'm glad you feel that you had your opportunity to be heard. Mr. Cox, anything further? Very well. You may go to the bailiff. Good luck to you.
Thank you, sir.
What are you studying?
Well, I'm trying my best, but I'm only an undergraduate right now, but eventually I would do law.
Eventually, I'll do law. Oh. Okay. Oh, Okay.
Welcome to the Licking County Municipal Court, ladies and gentlemen. My name is Judge Stansford. I'll be presiding over your arraignment, not until after we've done our jail cases. We always do those first. And we got a few in the other day, so I appreciate the patience. Good afternoon, Officer Riley. How are you today?
Oh, not too bad. How about yourself?
Let me just put it this way. This docket reflects the way my day's been going so far.
Yeah, pretty much.
All right. I know we had the one change. We'll go ahead and take Miss Shipley first.
All right. Shipley.
Good afternoon. You're Miss Shipley.
Yes, hi.
You understand your rights in court today?
Yes, I wasn't aware of what my birthday was until like the day of.
I don't remember asking you a question, Miss Shipley.
Sorry.
Yeah, dude.
Yes, I'm
Why did you
aware.
show up for court?
Because my grandma told me the day of that it was February 9th, and that's when she called me, and so I wasn't aware that that's when I had to work. I wasn't told. I didn't know. I promised. Like I had every intention to go there. I promised. But she like.
Is this your grandmother's case?
No, it's not, Your Honor. I should have looked up the court date.
Well, I did your arraignment, so I'm sure that if we go back and we play the video recording of your original arraignment, it's going to show me telling everybody, including you, that you could track your own case online or call the clerk's office or physically come in, and so that there's no excuse for missing court because you, quote unquote, didn't know when it was.
No, you're right. You are right. You're right. I promise if you order me, I promise I will not miss it. My court, I'll definitely track it. I still have my job at McDonald's. I made a mistake. I thought it would be further out, honestly. Like that's why I didn't. That's why like it took me. Like that's why I didn't even. I thought it was a month. But I mean, I don't know. I just thought it was.
What is your current mailing address, Ms. Shipley? So it hasn't changed, correct?
Right.
And which McDonald's do you work at?
Going to Union Street.
The one on what?
Union Street.
And how long have you worked there?
Yeah, on Union Street.
Yeah, how long have you worked there?
I was going on 3 months now.
Now, you've never had an attorney on either of these cases. If you want, you can submit an application for court-appointed counsel. You obviously have the right to hire your own lawyer if you want. I strongly suspect had you actually shown up to the trial date, you would have asked for a continuance that day in order to get an attorney. So if you want to get one, you'll have a chance between now and the time your cases are rescheduled for a trial. When I issued the warrants for your arrest, in the Salt case, I set the bond at $5,000 cash or surety only, and I set the bond on the obstructing charge at $1,500 cash surety or 10%. I'm going to make them both 10% bonds, but I am going to leave them in the same amount that they were on the warrants because we need to get these matters resolved. So $5,000 cash surety or 10% on the assault case. Again, no contact with the alleged victim. $1,500 cash surety or 10% on the obstructing, and you can get an application for court-appointed counsel down there at the jail. Do you have any questions?
No, Your Honor. Thank you.
Thank you. You may go with the officer. I'll see you next time. Timothy Lowry. All right. Mr. Lowry, you understand your rights in court today?
Yes, sir.
Did you receive a copy of the motion for oral hearing?
Yes, sir.
That's kind of a misnomer. Really, it should be called it's actually an addendum to a motion for oral hearing on this matter. So they've already filed a motion to revoke your probation. I believe you entered a denial. We had Ms. C appointed to represent you. Then a new warrant went out on February the 11th, alleging GPS monitor violations. So anyhow, let's look at this new addendum. It says that you caught a new criminal case and you failed to comply with the SCRAM GPS participant agreement. It would be my inclination to just simply go ahead and enter a denial on this addendum as well, since you've entered a general denial to the first one. But is there anything that you want to say before I set your bond?
Yes, sir. That I told my probation officer that I thought something was going on with the battery in the GPS because I kept the GPS battery charger with me to keep it charged at all the time. If it beeped, I would charge it, and that's, I mean, really all I did. I kept, if it beeped or anything, I would charge it. I would try to keep it for the 2 hours, to stick with the stipulations of the tracking.
Okay, thank you. We have a representative from the prosecutor's office here. Ms. Yeager, did the state wish to be heard regarding the matter of bond?
Yes, Your Honor. So I believe Mr. Lowry has retained Mr. Seth Smith on all of his cases now.
Okay.
His newest case, he was just arraigned for last week by Judge George. It does involve another protection order violation against the same victim. In which he placed a phone call. I do know that the PV of the PV violations include his GPS not staying charged. So much so that even the victim got a notification from the app that she had downloaded. So she was concerned that he was not charging it and then therefore would not be able to be tracked if he was around her, following her or anything like that. It seems like every time Mr. Lowry gets out of jail, he commits a new offense. So for that, Your Honor, we would ask that the court not permit a 10% and just require cash or surety only on the PV, especially since the addendum has been filed showing new conduct and if it's the original violation.
Okay, thank you, Mr. David. What is your current address, Mr. Lowry?
Newark, Ohio, or Heath, Ohio, excuse me.
Okay, so today I'm going to set bond at $10,000 cash or surety only, no consumption of any alcohol or drugs. If you do post the bond, you're reported immediately to the probation department. I believe we have a hearing scheduled for March the 11th on the original motion to revoke. This will be addressed at that time as well. Mr. Smith will receive notice of the hearings and in turn notify you. Do you have any other questions today, sir?
No, thank you.
Very well. You may go with the officer. See you at your next court date. All right, next we have Lindsay Farrington, and is that you? Okay, so Mr. Farrington, you're not Mr. Farrington, because Mr. Farrington is a Mrs. Good afternoon, are you Miss Farrington?
Yeah.
Very good. Do you understand your rights in court today? Did you receive a copy of your ticket?
Briefly.
Okay, well, it looks like it's the, so, yep. Looks like the sheriff's office alleging that on or about February the 15th of this year at about 5:30 in the evening, you were driving a dark blue 22 Ram pickup truck on State Route 310. They're alleging that you did that while you were under an OVI suspension and also under a 12-point suspension. So both of those are misdemeanors of the first degree. Each carry up to 180 days in jail, up to a $1,000 fine. The driving under an OVI suspension charge carries a maximum license suspension of up to 1 year. And that charge has mandatory minimum penalties. The license suspension is at least 1 day. The fine is at least $250. And there's actual mandatory jail time there of at least 3 days. Do you understand that those are the charges that have been filed?
Yes, Your Honor.
So how do you want to plead today?
My attorney was supposed to be there. I do have driving privileges. I just had cleaned my car out and realized I took the piece. I didn't realize I took the piece.
Let's go ahead and enter pleas of not guilty. Who's your attorney?
It's Jim Gilbert, James Gilbert.
All righty. You're going to want to get in touch with him once you get released, all right?
Okay,
Do you work?
I do.
What do you do?
I work at both Dickie's Restaurant and Depot in Pataskal. One's in Newark and one is in Pataskal.
Okay. The place up on 21st Street?
Correct. Yes, Your Honor.
And how long have you worked at each of those places?
Since August.
Okay.
7 months.
Well, here's what we're going to do today, Miss Farrington. Let me look. So I'm going to release you on your own recognizance on these charges. However, it would appear that the probation department has placed a holder on you. So you're obviously on probation, I think, for the underlying OVI charge. Was that case assigned to me or Judge George?
I don't remember. I'm sorry, Your Honor.
That's okay. I mean, do I look familiar?
You do.
Well, I don't know whether it was me or not, but here's what'll happen. Sometime within probably about the next 24 hours, the probation department's going to make a decision about whether to formally file a motion to revoke your probation, or they're going to drop that holder. Your recognizance bond is conditioned upon you reporting to the probation department immediately upon your release. And you can check things out with them. If they decide to file the motion to revoke, then I will see you at this hearing, but on the day that they file that. And they'll give you a copy of that before you have to go into court. But for now, you're being released on your own recognizance. This case will be randomly assigned to a judge set for a trial until Mr. Gilbert or any attorney submits a notice of representation. Then we will be sending all correspondence directly to you. What is your address?
Pataskal.
And what's your zip out there?
43062.
Very well. So, you have any other questions today?
No, Your Honor.
And you may go with the officer. Thank you. All right. Next up is Edward Folk. Now it's your turn. You understand your rights in court today?
Yes, sir.
All right. You get a copy of the complaint.
Yes, sir.
Read it. Understand you've been charged with one count of theft.
Yes, sir.
So that's a misdemeanor of the first degree. Carries up to 180 days in jail, up to a $1,000 fine. You understand?
Yes, sir.
You have a right to have me read your complaint if you want, but it's not required. Would you like for me to read it?
No, that's fine.
Okay. How do you want to plead today?
I'll do it.
You say not guilty?
Yeah.
Okay, that's fine. What's your address?
420.
Are you employed?
Yes.
Where do you work?
I'm looking for, downtown work right now, so, Philly.
Okay. Take a quick look here.
Where to get OR for Philly, man.
All right, let me check on one last thing, Mr. Folk. This is the only charge that you're facing, or the only charge that the jail roster has you being held on. It's a nonviolent offense. You have ties to the community. I will release you on your own recognizance today. The case will be randomly assigned to a judge, set for a trial. We'll get you notice through the mail. If you're going to get a lawyer, get the application from the jail, but you'll have to turn it in now that you're being released. You know the drill. Don't wait until the day of trial. All right? All right. You have any other questions today, Mr. Folk?
No, no problem. Yeah,
You may go with the officer. Thank you.
Thank you.
All right, next we have Martin King. Good afternoon, sir. Are you Mr. King?
Sir.
All right, so Mr. King, you're here because Judge George issued a warrant for your arrest. Looks like last week. You were scheduled to have an oral hearing on a motion to revoke bond. And when you did not appear, they went ahead and issued the warrant. And because your case was assigned to Judge George, the only authority that I have is to reset your bond and have the matter referred back to Judge George. Do you understand?
Yes, sir.
Okay. The other thing I wanted to advise you of is that your court-appointed counsel did withdraw as counsel, citing an irreparable breakdown of in the attorney-client relationship. So if you do want to have an attorney for this, you're going to have to fill out a new application. Okay.
Okay.
All right. So what is your current address, Mr. King? Your apartment?
Apartment C.
C is in Charlie?
Yes, sir.
Okay. And then what city is that in?
Tasca.
Okay. What's your zip out there?
43062.
Are you employed?
Yes, sir.
Where do you work?
Tim Hortons.
Okay. The one in Pataskla?
Yeah, and I'm going to school, like, it's the college of Zane State College of, I'm getting my diploma there. So, like,
What are you studying?
I'm actually getting my diploma.
Sorry?
It's a program through Zane State. Getting my diploma though, like I'm missing classes and everything right now. Like I knew about my they never sent it in the mail. They sent him I got in the mail for my trial date. That was on the 27th of February. I never got nothing for no hearing or nothing like that. So I had verification that I had sent to George saying that I got for the hearing on the 27th for the trial. That's the only thing I knew about. Like
Okay. All right.
you know, he withdrew and all that though, so like it was
Right. So hold on a second. Okay. Now, according to what the information that I have, they actually arrested you at your home.
yeah.
Okay, and it looks like that was on the 13th, which was Friday, and they're saying it's about quarter to midnight. No, about a quarter to 11. Why did the police come to your house? Because of the warrant, or were they called?
Yes. Because of the warrant though, and I didn't know nothing about nothing about it. Like I said, I got the court for my so when you looked online, it said like when you go to the Lincoln County website, it said February 27th at 8:30. That's the one I knew about. I didn't know nothing about it. My attorney, like I said, she withdrew, so I didn't know nothing about no hearing or nothing like that. So
Yeah, it looks like so he filed a motion on the 10th of February, but Judge George didn't sign off on it until this morning. So theoretically, she was your attorney of record. So I'm going to set your bond at $5,000. I'll make it cash surety or 10% and refer the matter back to Judge George. And like I said, if you want to get a new lawyer, you got to fill out a new application. Any questions?
no, man.
All right, you may go with the officer. Thank you, Mr. King.
Why still have my trial date for him on the 27th?
That I do not know, but you will get, unless you get a lawyer, the notices are now going to go directly to you. So make sure that we have a good address for you. Any other questions?
No, that's it.
All right, you may go with the officer. Thank you, Mr. King.
Thank you.
Next we have Scott Somerville. Good afternoon, sir. Are you Mr. Somerville?
Yes, sir.
All right, Mr. Somerville, you're here because I issued a warrant for your arrest when you failed to appear for a pretrial earlier this month. What we're going to do today is go ahead and set a bond for you, and then we're going to get this matter rescheduled. What's that?
I just plead guilty. I was gonna do it when I came to my pretrial last time. I didn't show up.
You can't do it today. If you still want to do it at your next court hearing, we can do it then. Okay? What's your current address?
Close, Ohio, apartment H.
Okay. We still have, as of January the 5th, we still had the Heath address down there on South.
Yeah, I had just moved, sir.
Okay. Well, it's your responsibility to keep a current mailing address with the court at all times, okay?
Well, I've been in the hospital, man. I've got stage 4 COPD. I've been in the hospital for the last 2 weeks. I'd only been out of the hospital for a couple of days before my trial.
So this says that you got taken into custody most recently on a warrant relay. Were you arrested in a different county?
Yeah, in Columbus, where I live, sir.
And how does it that you came into contact with the police for them to know that you had a warrant?
Tail light was out.
So you were in a vehicle, got pulled over, they asked who you were. And
Yes, sir. I just come back from the hospital. I just got all my teeth removed Friday. I got 24 teeth extracted. We were on the way back to the emergency room, actually, when I got pulled over. So when I got picked up, when y'all picked me up, they had to take me back to the emergency room. I was in the emergency room for 7 hours. And I've been on a liquid diet since I've been here, sir, since Friday. And I get 2 glasses of milk and a vegetable soup. Yes. I won't eat nothing.
Here's what I'm going to do for you today, Mr. Somerville. I'm going to go ahead and I'm going to release you on your own recognizance and not require that you post a bond in order to be released. However, if you fail to appear in the future and you get picked up on the warrant, then when you come back next time, there isn't going to be.
We did call in that day. We did call in. We knew we couldn't make it. We did call in that morning, and they appointed an attorney to me. And I tried to get in touch with the attorney, and I couldn't. I haven't talked to the attorney since I've called her like 8 or 9 times, but I still haven't talked to her.
Well, I'm going to provide that she gets a copy of this entry so that she knows that you were arrested on the warrant, that you've been released.
Yes,
We
sir.
need to make sure we have your new current address when you do your bond paperwork down there. And I understand what you're saying. Just continue to try to remain in as close contact as possible with your counsel. Do you have any other questions?
Your honor, I didn't hear you.
Do you have any other questions today, sir?
No, sir.
Then you may go with the officer. Thank you, Mr. Somerville.
All right. Thank you, man.
No problem, man. James Weaver. Good afternoon, sir. Are you Mr. Weaver?
Yes, sir.
Apparently this weekend was, hey, let's all get arrested on our warrant, our failure to appear warrants, because that's why you're here. You were scheduled for I want to say it was probably a diversion hearing. Or pretrial conference back in December. So what we have to do today is go ahead and set a bond for you and get this matter rescheduled, okay?
Please, thank you.
All righty. Now, what is your current address?
I was staying with some friends.
Well, I mean, do you have like a permanent mailing address that you use, or at least it's,
Yes, I do.
and that is what?
132.
Oh no. I know exactly what happened. It's an editing issue. Oh, for crying in the mud. Oh, I'm sorry. I guess we don't get to see the last part of the arraignment. I don't know where it went. and these were cut because they weren't interesting at all. It's all right. It it was just that last, there was that guy and one more. That was it. I'm learning new editing software because CapCut censors me and I don't like being censored. They wouldn't let me export my video because they didn't approve of my content. And I'll be darned if someone's going to tell me what I have a right to make and show. Let's see, which one? Actually, it's been Tiny Kitten up here lately. Or Earl. Earl usually. Yeah, I just called your, I said your name. I did, Tiny. I did. Yes, my tiny kitten, baby girl. You are not eating more frozen treats or freeze-dried treats. Nope, not now. Nope. Not right now. Nope. But you can have a few of these, just a few. Mama, tiny baby. Well, sort of. Oh. All right, guys. Oh, I figure I better make the announcement now. I will not be on tomorrow. I'm sorry. I apologize in advance. My baby girl's coming home to visit for a day. And she has a final that she has to take online on Friday. So she very, very sweetly asked me if I could pretty please not stream. Because for some reason, she can't sleep when she's here. Because I laugh loud. Oops. Bye, tiny kitten. So, yeah. I don't know that's a thing. I don't think that works. So, yeah. I'm sorry, guys. But I do have to spend time with my baby girl. I mean, I haven't seen her since it's been a minute. Earl, buddy, you are really close to that keyboard. Would you like some? You haven't had any yet. You haven't. Here you go, baby boy. Yeah. Tiny kitten, pigged out on him. Oh, Earl likes them. Oh, wow, he went right for it. Good. I would have to pay for it. No. Be very, very quiet. We're hunting duck. All right. But on that note too, she's gonna be here in the morning, so I need to go to sleep. She's got a doctor's appointment that I have to take her to. So it's kind of why I started early. Are you happy now? Now that you've tipped the box on its side? And you're going to jump in and shred all of that packing paper. I know you are. It's like your favorite thing to do. Okay, Earl. Earl, you skipped one. Earl. Earl, you missed one. He loves them. These are the Montusun. I told you she was going to go after that packing paper. All right, guys. Thank you so much. Thank you for coming and hanging out with me and tolerating my technical difficulties. I will learn this software. It's just a box. Be safe, be well, sleep sweet, and much love.